Good day, sir. My name is Arjun A. Zarate, B is Criminology 1, Block A. Rule 112, Preliminary Investigation. Section 1. Preliminary investigation defined when required. Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Except as provided in Section 7 of this rule, a preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by a law is at least 4 years, 2 months, and 1 day without regard to the fine. Section 2. Officers authorized to conduct preliminary investigations. The following may conduct preliminary investigations. A. Provincial or city prosecutors and their assistants. B. Judges of the municipal trial courts and municipal circuit trial courts. Letter C. National and regional state prosecutors. Letter D. Other officers as may be authorized by law. Their authority to conduct preliminary investigation shall include all crimes cognizable by the proper court in the respective territorial jurisdictions. Section 3. Procedure. The preliminary investigation shall be conducted in the following manner. Letter A. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of the complaint and these witnesses as well as other supporting documents to establish probable cause. They shall be in such number of copies as there are respondents plus 2 copies for the official file. The affidavits shall be subscribed and sworn before any prosecutor or government official authorized to administer oath, or in their absence or unavailability before a notary public, each of whom certify that the personality examined the affiants and that he is satisfied that they voluntarily executed and understand their affidavits. Letter B. Within 10 days after the filing of the complaint, the investigating officer shall either dismiss it if he finds no ground to continue with the investigation, or issue the respondents attach to its copy the complaint and supporting affidavits and documents. The respondent shall have the right to examine the evidence submitted by the complainant, which he may not have been furnished, and to copy them at his expense. If the evidence is voluminous, the complainant may be required to specify those which he intends to present against the respondent, and this shall be made available for examination or copying by the respondent at his expense. Objects as evidence need not be furnished a party, but shall be made available for examination. Copying or photographing at the expense requesting party. 30. Within 10 days from receipt of the subpoena with the complaint and supporting affidavits and documents, the respondent shall submit his counter affidavit and that of his witnesses and other supporting documents relied upon for his defense. The counter affidavit shall be subscribed and sworn. To and certified provided its paragraph. A. Of this section, with copies thereof furnished by him to the complaint, the respondent shall not be allowed to file a motion to dismiss in lieu of counter affidavit. D. If the respondent cannot be subpoena or subpoenaed, does not submit counter affidavits within 10 days, the investigating office shall resolve the complaint based on the evidence presented by the complainant. 3. The investigating officer may set a hearing if there are facts and issues to be clarified from a party or a witness. The parties can be represent at the hearing, but without the right to examine or to cross-examine. They may, however, submit the investigating officer questions which may be asked to the party or witness. The hearing shall be held within 10 days from submission of the counter affidavits and other documents or from the expiration of the period for their submission. It shall be terminated within 5 days. F. Within 10 days after the investigation, the investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial.